Look at this line chart tracking federal civil litigation. The baseline reflects typical case volumes until mid-2026, when the system logs a massive vertical spike. Breaking down this surge reveals highly concentrated clusters, over 16,000 lawsuits naming Kristi Noem and 15,000 naming Mark Wayne Mullen. These numbers are highly irregular because of who is being targeted. These suits are aimed directly at historically insulated administrative departments, including the Department of Homeland Security, the agency ICE, and Customs and Border Protection. Agencies that traditionally operated quietly in the background are now the primary sites for intense partisan warfare, drawing thousands of legal challenges. This cascade of litigation traces back to a single procedural trigger. To understand how the stability of the American bureaucracy fractured, we have to look at the firing of one federal trade commissioner. For 90 years, the rules governing independent agencies were anchored by a 1935 Supreme Court decision called Humphrey's Executor. That ruling established that Congress could mandate a specific cause, like malfeasance, inefficiency, or neglect of duty, before the president could fire the head of an independent agency. This for-cause requirement created a legal buffer. It ensured that federal agencies were insulated from daily political demands and managed by nonpartisan civil servants. In March 2025, President Donald Trump fired 2 Democratic commissioners at the FTC, including Rebecca Kelly Slaughter. He provided no stated cause for the removals. By bypassing the established legal protections, the administration initiated a direct challenge to the limits of executive authority. Rebecca Slaughter filed suit. Pointing to the binding 1935 precedent, a federal district court and the D.C. Circuit Court of Appeals both ruled the firing unlawful and ordered her reinstated. The federal government immediately appealed. Within weeks, the Supreme Court intervened, issuing an emergency stay that blocked Slaughter from returning to her desk while they reviewed the case. On June 29, 2026, the Supreme Court issued its decision in Trump v. Slaughter. In a 6-3 ruling split along ideological lines, the court sided with the president. Chief Justice John Roberts wrote the majority opinion. He rejected the decades of reliance on Humphrey's executor, describing the old precedent as a dried husk of constitutional law. The court established a new boundary for federal power. They ruled that the Constitution's separation of powers expressly prohibits Congress from requiring the president to have a reason before firing a subordinate. With that decision, Humphrey's executor was overruled completely. The legal barriers shielding independent agencies from the Oval Office collapsed. Tenure protections across the administrative state dissolved overnight. Agency commissioners and thousands of career civil servants effectively became at-will employees. The only exception was the Federal Reserve, which maintained its independence through a separate ruling due to its massive direct impact on the U.S. economy. Justice Ketanji Brown Jackson outlined the practical effects of the ruling in her dissent. She warned that the decision allowed a president to fire scientists, doctors, and economists and replace them entirely with political loyalists. This newly unchecked removal power facilitated immediate, sweeping personnel changes, driving the mass federal layoffs initiated by the Department of Government Efficiency. If we place the date of the Supreme Court ruling onto our initial litigation chart, it aligns precisely with the start of the massive spike. The sudden politicization of these agencies and the subsequent mass dismissals triggered the 2026 legal avalanche. The decision to fire Rebecca Slaughter centralized authority directly in the Oval Office. By erasing the protections of independent agencies, the ruling consolidated executive supremacy over the American bureaucracy.